Okay, let's go on the record on cause number DC 1911481 Mingtel Inc. versus Comerica Bank et al. Counsel, make your appearances.
Rebecca Vaughn, Your Honor, for Plaintiff Mingtel.
Bruce Bowman and Charlene Becker and Kristen Burns on behalf of Comerica.
Let's go ahead and proceed.
Thank you, Your Honor. As you're aware, there was a trial that was held in this case that began on August 18th of 2020, I believe, and it concluded on the 25th. The trial covered only one cause of action that was asserted by Mingtel, and it was money hadn't received against Comerica. This court made its ruling on October 1st of 2020, and it found in favor of Comerica on that claim. Mingtel is now requesting that the court either reconsider its final judgment or vacate and set this for new trial. Plaintiff is requesting that the ruling should be in favor of Mingtel as the evidence is legally and factually insufficient to support the final judgment as it stands today. As a cause of action for money hadn't received is equitable in nature, it requires no showing of culpability to prevail on the part of Mingtel, nor does it require any showing of good faith for Comerica to defend. It is really as simple as tracing the money and determining the character of the underlying transactions. The facts in this case, as well as the relevant case law, has been greatly and thoroughly briefed for this court by both of the parties. And unless the court requests otherwise, I will not go into too much of great detail before you today on those matters. Instead, the plaintiff would like to urge the court that its finding in favor of Comerica was in fact in error. And this is largely shown through the deposition of Mr. O'Keefe, who was the Chief Restructuring Officer for PCT. That deposition, the transcript of such, was admitted at trial and demonstrates that Comerica was vastly involved in PCT's business and knew exactly what type of business PCT was involved in. The portions of this transcript that were used, which are also attached to our motion for your convenience, greatly details Comerica's involvement and their close business relationship with PCT. This relationship was far more than just a secured lender and business relationship, as Comerica has argued before this court. Every transactions and business decision was made with the help or at the direction of Comerica through O'Keefe during the restructuring phase. O'Keefe has further testified that Comerica was familiar with the business of PCT, testifying that Mingtel was only one of several vendors of the same nature. Therefore, knowing that this consignee-consignor relationship was not just isolated in nature. In the alternative, Your Honor, this court should grant a new trial. This court is aware that the determination of Comerica's involvement and their knowledge of PCT's business really became the sticking point that the entire case hinged on. This court is also aware that this single most important issue was largely not appreciated by either party until really the first day of trial. If anything, the evidence that the court has before it shows that in the interest of justice, a new trial should be held to further develop the evidence and determine Comerica's knowledge of PCT's business ventures. The court in this case would greatly benefit from the testimony of one of Comerica's representatives, which could only be possible through a new trial. The plaintiff is requesting that this court reconsider its judgment and find in favor of Mingtel, but in the alternative, if the court decides to decline to reconsider, that a new trial be had so that justice may be done. Thank you, Your Honor.
I read your briefing where it didn't look like there was any, this isn't based on any new case law or on any new case law or new facts that have come up, correct?
That's correct, Your Honor, and we do believe that probably the most beneficial remedy here would be a new trial so that we could take the testimony of one of Comerica's representatives so that that may be further developed for the court and we could all see really Comerica's involvement with PCT and their knowledge of PCT's business during this time.
Mr. Bowman?
Please, court, Your Honor. We, of course, think that it should be overruled. As you have pointed out, there is no case law, there is no allegations of new evidence because there is no new evidence. And so we think it should be overruled. They have, of course, properly filed a motion for, well, they filed their notice of appeal and they're in the appellate court at the moment. And as you, I think you realize, you're in your plenary power. So you do have plenary power to do something. But, 75 days is up, but they did file their notice of appeal. So they are actually in the Dallas Court of Appeals. And if they really want to test it, they're already there and they can test it. Well, we think there's nothing to be gained by having a new trial. We had a full trial. Matter of fact, a representative of the bank did testify. Mr. O'Keefe testified, and as cited, I guess, in our response, most favorable thing they have are he, remember, was not an agent or employee of the bank. He was hired as a third party by the borrower. Are you aware of any contract terms between BCT and those vendors? And he said, no, not specifically. So there's just really no reason to have this. I think that the Texas law shows, and the facts is that you were correct.
Bowman, I hope you're right. As I told you before, I thought this was a very close call. I've only been reversed once under the new Court of Appeals. I really don't want to get reversed this time.
I really can't think. There's bound to be a time. I've practiced so long, but I can't really think of a time anybody has reversed me on something I prevailed on. I have reversed some others. Of course, that's kind of fun, but I don't think so. I hope this is not the first, Your Honor. I don't think it will be.
I mean, I've urged you guys to settle on multiple occasions. I don't know that if it would be helpful to send you back to mediation again, or that's just as a fool's errand at this point. But I do think this is a very close call. Is there any chance this could settle at this point or no?
I really don't think so. I think Beck and I tried before the final hearing on all this, and we're just not particularly talking the same wavelength. While we're talking settlement, we're not talking in the same hemisphere.
Yes, not for lack of good faith effort on my part and the part of Mr. Bowman, but I think our clients are just in different books, if not different pages.
And this is always hard. I mean, because it's neither of you guys really did anything wrong. I mean, it would have been helpful if Ms. Vaughn's client had filed the financing statement, or what is that what it's called, financing statement? Maybe we have the terminology wrong. I don't recall, but even it was just, you had two innocent folks that are innocent parties that both had some entitlement to these funds, and it was just, I felt based on the law that at a very close call that the bank should get this, but I still think there's a chance the Court of Appeals may disagree with me, and would much rather you guys try to work something out if you can, but I understand if you can't. All right. Well, so I guess I'm going to go ahead and let me ask this, Mr. Bowman. Do you feel like it would make sense to do a new trial and let her develop this evidence so that you'd have a better shot on appeal if this went on appeal, or?
No, I'm comfortable with this on appeal. A new trial would just run up a bunch more fees.
Okay. All right. Ms. Vaughn, I thought you guys did a really good job in this trial. I do really think this is a close call. I could see this going either way on appeal. So I'm going to go ahead and deny the motion for new trial and for JNOV and wish you guys the very best of luck. Okay.
Thank you,
Thank you, Your Honor.
Thank you.
On a side issue, just have nothing to do with anything. I actually was able to get vaccinated today.
Oh, were you?
Yeah, I thought you might be interested in that. Yeah, it's kind of UT Southwestern is giving it to their